Good afternoon, everybody, and welcome to Mediation Ethics and Practice, East versus West, New York and California. This is the second program in our NYCLA 90210 series, and we're thrilled to be here. I'm Barry Chase, the CLE Director at NYCLA, and I have a few announcements before we begin. First of all, there are terrific course materials that have been prepared by our speakers, and I really encourage you to download the materials. The link to the materials is in your Zoom invitation that you received about an hour ago. And also for NYCLA members, the link is also in the email that you received from our registrar, Amelia Brzezinski. So please download the materials. For Beverly Hills Bar Association attendees, you will receive your California CLE certificates within 24 hours after the program. For NYCLA attendees, you will receive an email by next week with a link for where you can download your New York and or New Jersey certificates. And the link is also in the email from our registrar. Speaking of CLE certificates, we've had a lot of requests from people who are barred in California who may also want New York credit, and people in New York who are barred in California who may also want California credit. So if you do want dual CLE certificates, please send an email to cle@nycla.org. Again, that's cle@nycla.org, and we'll put that link in the chat as well, and indicate your name, your email, and which CLE certificates you want, and we'll take care of that for you. Okay? All right. Finally, we want to make this program as interactive as possible. So if you do have any questions for our speakers, please put the question in the Q&A box, which is on your Zoom toolbar. Please don't use the chat for the questions, as we use that for more general announcements, but please, we encourage you to ask any questions that you may want to ask. I want to thank all of our speakers for being here today and all of our moderators, and I especially want to thank the wonderful staff at the Beverly Hills Bar Association. That they've been fantastic to work with, and we're looking forward to the program. And of course, I especially want to thank as well NYCLA's ADR committee and their great co-chairs, Nelson Weinrev and Christopher Fladgate, and Vice Chair Nelson Tempton, who will be moderating the program for the New York side. And now I want to introduce LaVon Lawson, past president of the Beverly Hills Bar Association, who has some welcoming remarks as well. Thank you.
Thank you, Mari. Greetings, everyone. We at the Beverly Hills Bar Association and the litigation section are delighted to join the New York County Lawyers Association in this joint program on mediation ethics and practice. And we're delighted to join them in this programming series. Just a few words about the Beverly Hills Bar Association for those who don't yet know us. The Beverly Hills Bar Association, or BHBA as we like to call it, is a full-service bar association. It provides access to networking, CLE programs, speaking and publishing venues, and pro bono leadership opportunities. We have different levels of membership. It's a great value, and most importantly, it's a great place to make colleagues and friends. And you do not have to be in Beverly Hills to be a member of the Beverly Hills Bar Association. But with that, it is my pleasure to introduce the program moderators from the BHBA. Glenn Gottlieb is a trained professional mediator with a more than 35-year background in business and transactional legal practice. He has successfully mediated matters involving personal injury, premises liability, employment law, real property, and commercial disputes, and more. Mr. Gottlieb served as a member of the board of directors of the Southern California Mediation Section. He is a co-chair of the BHBA Mediation Section, and he got his JD from UC Berkeley. Adam Porter has been serving as a mediator for over 15 years. He accepts cases of all sizes in most practice areas, and he has a JD and a certificate in dispute resolution from Pepperdine University. He also earned his LLM from Georgetown. Mr. Porter is also a co-chair of the BHBA Mediation Section. So with that, I will turn this over to our moderators to introduce the speaker.
Great, thank you so much, LaVon. All right, we have a jam-packed agenda today. It's a pleasure to be working with everybody. And we're going to start things off with the New York perspective. Our first speaker is going to be Stephen Sonnenberg. Mr. Sonnenberg is an attorney, social worker, psychotherapist graduate of the University of Southern California, the Gould School of Law, and the University of Michigan. He has deep experience in understanding and resolving complex labor and employment disputes. As a member of JAM's Title IX panel, as well as a member of the mediation panels of the U.S. District Court, Southern Eastern Districts of New York, he has mediated numerous Fair Labor Standards Act and state law wage and hour collective and class actions involving employees and companies in the retail, hospitality, technology, healthcare, and transportation industries, among others. These actions have involved state-specific, multi-state, and nationwide claims. Stephen's experience in practicing labor and employment law for 25 years at Paul Hastings paved the path to his success as a mediator. His leadership roles at the firm included a term as chair of the New York Employment Law Practice, vice chair of the Employment Law Department, and co-chair of the Employment Law Department's National Wage and Hour Practice. Beyond his work as a mediator, Stephen has taught employment law to members of the federal judiciary through the Federal Judicial Center, provided employment law training and advice in a variety of settings, and is an adjunct faculty member at Cardozo Law School. He will be speaking to us today on confidentiality in mediation, the New York perspective. Stephen, the floor is yours.
Thanks very much, and delighted to be here. And I would just add to that I practiced in California from 1992 to 2006, and I was a member of the Beverly Hills Bar Association, so it's nice to be here. I don't want to jump into talking about mediation confidentiality in New York, though, without mentioning what you may think is obvious, why confidentiality is important to begin with. Here's what the Second Circuit Court of Appeals had to say about that in a 2011 decision, Intelligent Incorporated versus K&L Gates. The court summed it up this way. Confidentiality is an important feature of the mediation and other alternative dispute resolution processes. Promising participants confidentiality in these proceedings promotes the free flow of information that may result in the settlement of a dispute and protecting the integrity of alternative dispute resolution generally. And the Second Circuit added, were courts to cavalierly set aside confidentiality restrictions on disclosure of communications made in the context of mediation, parties might be less frank and forthcoming during the mediation process, or might even limit their use of mediation altogether. I would put it this way. Without confidentiality, it's more difficult to develop trust in a relationship with a mediator. And trust is fundamental to a meaningful relationship between the mediator and those participating in mediation. Since I believe that mediation is very much about developing a relationship between the mediator and those attending, however brief that relationship may be, I think confidentiality is important. But there's a very pragmatic reason to focus on confidentiality in mediation right now. Just as the use of mediation has really increased dramatically in recent years, also has the potential for disputes that touch on mediation. A post-mediation dispute might involve issues having to do with the underlying dispute in the mediation or disagreements over the existence, validity, or terms of a settlement agreement reached in mediation, or claims of mediator or attorney misconduct. Those are just a few examples. In these post-session disputes, a party may want to introduce statements made during mediation or documents created in conjunction with the mediation or events that actually took place during mediation. That means that someone, perhaps a party to a mediation or a third party, may try to surmount the confidentiality of the mediation in discovery, or at trial, or in an administrative proceeding. So the rules that shape the parties and the mediator's expectations for confidentiality, whether they're grounded on state law, case law, court orders, or agreements that are voluntarily entered into by the parties before the mediation even begins, are important. So with that in mind, imagine a professional world in which there's a uniform act that would govern confidentiality and mediation throughout the country. Certainty, clarity, uniformity, and simplicity would result. That world doesn't exist. Now, consider the Uniform Mediation Act, drafted by the National Conference of Commissioners on Uniform State Laws in 2001. That act basically focuses on whether mediation communications are discoverable or admissible in legal proceedings. And Section 4 of that act provides for certain mediation privileges so that mediation communications, subject to certain exceptions and waivers, are privileged, not subject to discovery, and not admissible in a proceeding. Under this act, the UMA, a mediation party can refuse to disclose and may prevent another person from disclosing a mediation communication. A mediator may refuse to disclose a mediation communication and may prevent any other person from disclosing a mediation communication of the mediator. And there are provisions that identify exceptions to the privilege in certain circumstances, such as threats of bodily harm, admissions of abuse or neglect, or when there's certain evidence available, such as if the mediation was used to further the perpetration of a crime, if a mediated settlement agreement was induced by fraud or duress, or if the mediator or representative of a party engaged in professional malpractice or misconduct. But the UMA, unlike a written confidentiality agreement that you may have participants sign before beginning a mediation, doesn't expressly prohibit the participants, other than the mediator, from disclosing mediation communications in contexts other than legal proceedings. So I think around 13 states, most recently Georgia, have adopted the UMA. New York is not one of them. Instead, confidentiality in New York in mediation is impacted by a patchwork of local rules of court, general orders, court-ordered standard form confidentiality agreements, private confidentiality agreements, and of course, case law. So for the first patch in that patchwork, I want to talk about mediation confidentiality briefly in New York state courts. A decade before the UMA was drafted, New York established the Community Dispute Resolution Center program for the New York state courts. And that law expressly protects mediator confidentiality, again, subject to certain exceptions. Under New York Judiciary Law, Section 849B, work product and files of the mediator are confidential and not subject to disclosure in any judicial or administrative proceeding. Any communication relating to the subject matter of the resolution made during the mediation by any participant is a confidential communication. During 2020, almost 20,000 civil and family cases were referred for virtual mediation in the community dispute resolution centers. And mediation through these centers is not the only ADR program operating in the New York State Unified Court System. And that system has adopted what the chief judge has referred to as a presumption for early alternative dispute resolution. One New York State court addressing a dispute arising from pre-litigation mediation of a matrimonial dispute has concluded that this presumption for ADR across the New York State Unified Court System strongly suggests that the confidentiality of mediation proceedings protected in Judiciary Law 849B should apply broadly. And that's the Irizarry versus Hayes decision in 2020. And specifically, the court in Irizarry stated, if the mediation process, as envisioned by either the legislature or the Office of Court Administration in its presumptive mediation rules, were subject to an invasion through disclosure, depositions, and other devices, the entire purpose of mediation as an alternative to litigation would be extinguished. In addition to the New York State courts, the Second Circuit and all 4 federal district courts in New York have ADR programs with rules on mediation confidentiality. Some New York federal courts have taken a different approach than that used in the Community Dispute Resolution Center program. Several federal courts view mediators as functioning in a quasi-judicial capacity and protected as would be a judge or any other court official. There's another important role, though, that federal courts have taken with respect to confidentiality and mediation in New York. The Second Circuit, in that 2011 decision that I mentioned earlier, in Retelligent, formulated a 3-part test to apply when a party seeks disclosure of confidential mediation communications. In the Telligent case, A third party moved the bankruptcy court to lift 2 protective orders that barred disclosure of communications made during mediation. The mediation had been conducted subject to a court order providing for confidentiality. Here's the 3-part test. First, a party seeking disclosure of confidential mediation communications must demonstrate a special need for the confidential material. Second, it would have to be resulting unfairness from a lack of discovery. And there would have to be a need for the evidence that outweighs the interest in maintaining confidentiality. All 3 of those factors are necessary under the test to warrant disclosure of otherwise non-discoverable documents. So that leads us to a key question. Does the Second Circuit's heightened standard for mediation disclosure apply to private mediations that are subject to a confidentiality agreement, but not a court order? To date, 3 courts have concluded that Telligent does apply to private mediations. One of them, a decision within the Southern District of New York in 2020 entitled Accent Delight International Limited versus Sotheby's, I think that's a great title, is particularly interesting. The court directly addressed the question of whether a party seeking to discover materials relating to a private confidential mediation must satisfy the 3-part test in Telligent. The court concluded that there are strong reasons why the answer should be yes. And the court found that the plaintiffs were not entitled to mediation materials that they sought after participating in a private mediation that was subject to an agreement of confidentiality. And what the court stated is actually worth my at least reading a couple of sentences of it. You may or may not agree with this, but here's what the court said. Among other things, providing weaker protections to communications during a confidential private mediation than to communications during a court-sponsored mediation would discourage parties from agreeing to engage in private mediation. But in many cases, particularly more complex cases, private mediation, which is often conducted with a paid, highly experienced mediator who can devote more time to the matter, may be preferable to and more likely to succeed than court-ordered or sponsored mediation. Incentivizing private mediations, or to be more precise, not disincentivizing them, benefits not only the parties in such cases, but also the court system generally, both because it alleviates the burdens on court-sponsored mediation programs, which are often thinly staffed by unpaid volunteers, and because, when successful, it lightens the court's docket. That's what the Southern District of Court had to say in that particular decision. But wait, we're not done yet with New York case law. Briefly, 13 years ago, the New York Supreme Court Appellate Division allowed a mediator to be deposed and his records to be produced related to a mediation that he had conducted with 2 spouses. That case is Hausinger versus Hausinger. The mediation ended with an executed separation agreement. The Appellate Division, noting the parties were not represented by counsel, decided that it had to determine whether the terms of the separation agreement were fair and reasonable at the time the parties made the agreement. It held that the lower court had not abused its discretion in refusing to enforce the confidentiality agreement entered into by the parties as part of the mediation. 1-paragraph opinion closed with this statement: New York has not adopted that act, the Uniform Mediation Act, and we decline to do so. And the Court of Appeals, in an equally cursory opinion, affirmed on other grounds. So the question is Hausinger still good law today? Well, a recent decision points out that the ADR climate in New York has evolved during the past 13 years. Remember that Irizarry versus Hayes decision I mentioned from 2020? The facts in Irizarry mirror those in Hausinger. A divorcing couple mediated a settlement agreement with the help of a mediator. Neither spouse had legal counsel. The mediator drafted the settlement agreement. 2 years later, the wife sought to set aside the agreement and the judgment of divorce, describing the agreement as unconscionable. The Irizarry court found that the mere fact that the settlement agreement was mediated and the mediator drafted the agreement doesn't by itself cause the court to be skeptical about the agreement. Rather, the Irizarry court found a presumption of validity which attaches to the signed agreement is strengthened because of the origin of the document in a mediation process. Noting today's climate favoring mediation, the court concluded that, court's words, to upend such an agreement should require clear and convincing evidence of a substantial flaw in the process, complete failure of financial disclosure, evidence of coercive tactics by a spouse, a biased mediator, a participant's continual complaints during the process. The court stated that it is wary of plunging a mediator and the attorney Scrivener into a carousel of depositions and discovery in an attempt to undermine the mediation process. So, in the 13 years since Hausinger, no court in any decision I've found has cited it to force a mediator to comply with a discovery subpoena. One court has cited Hausinger for the proposition that no mediation privilege exists in New York law when rejecting a claim of mediation privilege on a privilege law, noting as well that New York has not adopted the UMA. So, with that hodgepodge of case law and no UMA in New York in mind, what options do mediators in New York have when addressing confidentiality issues before a session begins? First, don't rely upon the Uniform Mediation Act in New York. Consider carefully what you will have parties and their counsel sign before mediation to address confidentiality. In my opinion, mediators need to be forthright with parties that the mediator should not be subject to discovery and proceedings after the mediation. Remember Section 849B of the Judiciary Law of New York for the Community Dispute Resolution Centers program that I mentioned earlier? That's one source to help guide you as to the content of the confidentiality provision in your mediation agreements. That section states in part that all memoranda, work products, or case files of the mediator are confidential and not subject to disclosure in any judicial or administrative proceeding. As another example, the mediation agreement used at JAMS provides in part that all statements made during the course of the mediation are privileged settlement discussion and are made without prejudice to any party's legal position and are inadmissible for any purpose in any legal proceeding. Of course, if you're mediating a court-directed dispute in, for example, the Eastern District or Southern District of New York, each of those courts has standard form agreements for the mediator and the parties to use. The Northern and Western Districts of New York have a local rule or a general order that protects mediators from discovery. And you may want to use these court-mandated provisions as additional guides as to the language that you might want to include in your mediation agreement. Keep in mind that no contractual clause can change rules of evidence or laws related to liability. But in New York, where some of the rules and the laws pertaining to mediators are ambiguous, including clauses addressing confidentiality, puts the parties on notice and documents the parties and a mediator's expectations and reliance about the terms of service that the mediators offer to provide. So, what do you do if you receive a subpoena in a judicial proceeding concerning a mediation that you conducted? For one thing, consider addressing this possibility in your mediation agreement. Here are a few potential provisions. Each party agrees to make no attempt to compel the mediator's testimony. Each party agrees to make no attempt to compel the mediator to produce any document provided or created by the mediator or provided by the other party to the mediator. The parties agree to defend the mediator from any subpoenas from outside parties arising out of this agreement or mediation. Want to go further? Here's another. Should the mediator be required to respond to a subpoena from any party involved in this mediation, that party will be billed for time and expenses incurred in connection with such a response. The parties agree that the mediator is not a necessary party in any arbitral or judicial proceeding relating to the mediation or to the subject matter of the mediation. If you're subject to discovery after a mediation, though, submitting to a subpoena or even a notice of deposition may very well be the low-cost way for a mediator to proceed in terms of money, time, and not unimportantly, emotions. But for the mediator who wants to take the more difficult path that potentially benefits all who engage in and rely upon mediators, challenging such a discovery request may very well be the way to go. And remember Hausinger versus Hausinger? That decision existed because a mediator stood up for himself and fellow mediators in the Appellate Division and the Court of Appeals of New York. Now, those courts didn't credit that mediator's arguments, both issuing that one-paragraph decisions back in 2007, 2008. And Hausinger it's like one of the first cases that comes up if you do a Westlaw or a Lexis search regarding mediation confidentiality in New York. That said, no reported decision that I found has relied on Hausinger in the past 13 years to order a mediator to submit to discovery. So the cleanest way to address Hausinger is for the Court of Appeals to overrule Hausinger in another case. Not that I'm wishing it upon anyone here or upon myself, but maybe one of us will one day have the opportunity to tackle that. Thanks very much.
Thank you very much, Stephen. I'm now going to turn the program over to Glenn Gottlieb to introduce our next speaker, Phyllis Pollock. Glenn, take it away.
Thank you very much, Elon. Welcome, everybody. Pardon me. On behalf of the Beverly Hills Bar Association, where I'm proud to be the chair of the mediation section, it's my pleasure and privilege to introduce my friend, Phyllis Pollock. Phyllis is, like Jeff, one of the more prominent members of our mediation community here in Los Angeles. She has made a specialty of lemon law cases, actually, outside for her profession, but also within our community, she's made a specialty of mediation ethics. She's taught at USC law in the mediation program there, and is just outstanding in the field. More importantly, she attended Tulane Law School, and we share a love of New Orleans since I clerked for a federal judge there after law school. So more often when we get together, we talk New Orleans instead of mediation or law. With that, Phyllis, take it away.
Thank you very much, Glenn, for that very generous introduction, and good afternoon, everybody. Unlike New York, California does have a statutory concept of mediation confidentiality, which the Supreme Court of California has strictly construed. And I'm going to spend the next few minutes going through the statutes with you. But first, I want to go through the quick history. In 1965, let me get rid of everybody. In 1965, California introduced Evidence Code Section 1152, which essentially bars admissibility of evidence to compromise during settlement negotiations. It's very much like the Federal Rule of Evidence 408. Then in the early 1980s, it enacted the predecessor to our current statutes, and that was Statute 1152.5, containing many of the mediation confidentiality provisions, which hopefully the California lawyers are familiar with. In 1993, the legislature enacted Section 703.5, which provides that in all civil proceedings, a mediator as well as an arbitrator, but we're concentrating on mediators today, are not competent to testify as to what occurred in mediation, and I'll go through that in a moment. Then, as you can see, in 1997, we enacted the current Evidence Code Sections 1115 to 1128, which, as I mentioned, drew from the provisions of 1152.5, which was then repealed. And then in 2019, Evidence Code Section 1129 was enacted, which is an informed consent or prior disclosure statute regarding the strictures of mediation confidentiality. So first, let's take a quick look at Evidence Code Section 703.5. As I said, it indicates that no mediator as well as arbitrator shall be competent to testify in any subsequent civil proceeding except in limited circumstances. And those include a proceeding involving civil or criminal contempt, about conduct constituting a crime, about an investigation being conducted either by the State Bar of California or the Commission on Judicial Performance, or a disqualification proceeding in which a party is attempting to disqualify a judge from sitting on a particular matter, or in certain family law mediations. California has also adopted quasi-judicial immunity for mediators, at least in court-connected mediations. This case arose, it's an appellate decision that arose in 1990 involving a family law dispute. The wife sought to preclude the husband from having or seek to terminate his visitation and custody rights. Wife alleged that hubby had sexually and physically abused the minor son. So the court sent them to mediation. The mediator mediated the matter and filed a report. The wife did not like, I guess, either the way the mediation was conducted and or the report, so sought to sue the mediator for essentially mediator malpractice. And the court said, no, you can't do it. Mediators have quasi-judicial immunity and cannot be sued. So now let's go into the statutes themselves. Evidence Code section 1115 is the definitional section, and it defines mediation essentially as a facilitated negotiation. Now, the definition of mediator is very interesting because it includes not only the mediator herself or himself, but also the person who may assist the mediator either as a co-mediator or assist the mediator in preparing for the mediation. This means that your case manager would come under the definition of mediator in California. And where this comes into play is if you look at the definition of mediation consultation, it includes any communication between a person and a mediator for the purpose of initiating, considering, reconvening a mediation or retaining the mediator. And as you will see in the next section, what this means is the minute that a party calls your case manager to set up a mediation, that will be covered by mediation confidentiality, because the next section, 1119 A and B, says no evidence of anything said or admission or writing made for the purpose of, in the course of, or pursuant to a mediation or mediation consultation is not admissible in a subsequent non-criminal proceeding. So when, as I said, when somebody calls your case manager to set up a mediation, mediation confidentiality applies. Now, subpart C of that statute is broader, and it says all communications, negotiations, or settlement discussions are precluded by mediation confidentiality from being disclosed. And it does include conduct that is intended as an assertion. So if you walk in and you've coming from the defendant's table and defendants has said, yes, we accept the settlement, and you walk into the plaintiff and you say, you have settled, congratulations, and the plaintiff either gives you a high five or gives you a thumbs up, that conduct will be covered by mediation confidentiality. The next section, 1120, basically says that evidence that would otherwise be admissible does not suddenly become inadmissible because it was used during a mediation. So if you use answers to interrogatories or documents that have been produced in response to a request to produce, they don't suddenly get cloaked with mediation confidentiality just because they were used during the mediation. And the next section set out the fact that that this section does not limit the following, which is an admissibility of an agreement to mediate, the effect of an agreement not to take a default or to extend the time or to forbear from doing something, or the disclosure of the fact that a mediator was contacted about serving, agreed to serve, didn't want to serve, etc. The last subsection is interesting. In California, under the family code, during divorces, spouses must file income and expense statements or financial disclosure statements periodically. And this section provides that those income and expense statements do not suddenly become inadmissible when they are used in mediation. And it arises out of the case of Lapp versus Superior Court, where the husband and wife went to mediation and they used their income and expense statements. And then in a subsequent court proceeding, the husband tried to preclude the use of the income and expense statement by saying it was produced in mediation. The appellate court said, that's not going to fly, because the income and expense statements are required separately and discreetly by the family code, and you can't cloak them with mediation confidentiality just because they're used in mediation. 1121 of our California Evidence Code says that a mediator's report cannot be required. A mediator cannot be forced to explain to the court exactly what happened in mediation, except if there is a court rule or other law. Then the most the mediator can tell the court is that a mediation was held, the parties showed up, and whether they settled or not. The court is not entitled to find out about the details of what happened, if somebody appeared in good faith, bad faith, or what have you. The next section, 1123, is extremely important in California because it talks about settlement agreements. And unlike Oregon and some other states, a written settlement agreement is not admissible in California unless one of these four conditions are met: that the agreement itself provides that it is admissible or subject to disclosure, that it is enforceable or binding, or words to that effect, that the parties either orally agree in writing, or that the agreement is used to show fraud, duress, or illegality that is relevant to the issue and dispute. Now, only the agreement itself will be admissible. The backstory, the reps, the warranties are not admissible. So at least for the California attorneys, I strongly urge you to put the representations and the warranties and the backstories in the agreement, because the court cannot take testimony as to or go behind the scenes of what happened should you have to file a motion to enforce the settlement agreement under our Code of Civil Procedure 664.6. So when does mediation confidentiality end in California? Obviously, it ends if the parties settle and there's a settlement agreement. It also ends if either the mediator or a party sends a letter to the others stating that it has ended. And by statute, it will end 10 calendar days after the last communication between the mediator and the parties. This time can be either extended or shortened. In my own agreements, I often put in a time limit of 180 days because I do cases that are in litigation, and sometimes parties need to take depositions or do other discovery before they can resume those mediated conversations. Evidence Code 1126 basically says that anything that occurs in mediation remains confidential even after the mediation ends, or to use the well-worn phrase, what goes on in Vegas stays in Vegas. To add on to a little bit of what Mr. Sonnenberg said, I don't have it up here, but our Evidence Code 1127 provides that should a mediator be subpoenaed to produce either a document or to testify in court, and should that motion be denied, then the mediator is entitled to get their attorney's fees from the party who served the subpoena or attempted to have the mediator testify. 1128 of our Evidence Code provides that any reference to a mediation in a subsequent trial is automatically grounds for a new trial in California. And any reference to a mediation in a subsequent non-criminal proceeding will be grounds to either vacate or modify the decision, or to grant a new or further hearing if that reference materially affected the substantial rights of the parties requesting the relief. Now, Evidence Code 1129 has a very interesting history, which Mr. Kichaven can also add to if he so desires. In 1997, as I mentioned, our current statutory scheme was enacted. And subsequent to that, many a plaintiff who was unhappy with the settlement tried to sue their attorneys for malpractice for what occurred in mediation. And more times than not, the defendant attorneys would file a motion to dismiss saying that it was all covered by mediation confidentiality, and indeed nothing was admissible. And indeed, in the latest case before the California Supreme Court in 2011, called Castle versus Superior Court, the court, as it had in the past, strictly construed these mediation confidentiality statutes, holding that mediation confidentiality applied not only to pre-mediation conversations, but to mediation conversations occurring during the mediation, even if outside the presence of the mediator. And the court said, basically, we must apply the plain terms of the mediation confidentiality statutes to the facts of this case, unless such a result would violate due process or would lead to an absurd result never intended by the legislature. The California courts have strictly applied these statutes, brooking no exceptions. And so a tension was created between the accountability of attorneys, that is attorney malpractice, and mediation confidentiality. So as a result of this Castle case, a group of attorneys got together, proposed an exception to mediation confidentiality for legal malpractice to the legislature. It was introduced. There was a lot of pushback. And so it was referred to the California Law Revision Commission that then studied the matter for 3 years, proposed their own statute, which also got a lot of pushback and so died on the vine. As a result, and during those hearings, the 3 years of study by the California Law Revision Commission, some folks said, well, rather than try to solve the problem after the fact by creating an exception, why don't we look at it in terms of informed consent or prior disclosure to tell a party up front before the mediation what rights they're giving up. And so when the California Law Revision Commission proposal died, a group of folks got together, came up with what is now 1129, which provides that an attorney representing a client participating in a mediation should provide to the client, prior to the client agreeing to mediation, a acknowledgement and disclosure form setting out the confidentiality restrictions. And if the attorney is retained after the case is litigated, the attorney should do that as quickly as possible. The form should be on a single page, 12-point font, in a language that the client prefers, includes the signature of the attorney and the client. And the statute sets out a little form, mediation disclosure, notification and acknowledgement, a sample. And if the lawyer uses this, the lawyer will be deemed to have complied. And basically the preface says that California has very strict confidentiality laws. And then it sets forth certain precise points that all communications, negotiations, or settlement offers must remain confidential, which parrots 1119C. The next one about statements and writings parrot Evidence Code section 1119A and B. The mediator's report parrots Evidence Code section 1121. The next section, that a mediator cannot testify, parrots Evidence Code 703.5. And then finally, you have this final section, which summarizes essentially 1115 to 1128, essentially saying that what occurs in mediation is confidential, which means that you may not be able to sue your attorney for legal malpractice. And then you have the acknowledgement by the client that they've read it, they understand it, that they may not be able to sue their attorney. And then they both sign it. Now, note that E provides that the failure of the attorney to comply with the section is not a basis to set aside the settlement agreement. At most, the client can file a claim with the state bar for disciplinary proceedings. And that's the only repercussion that I know of for not following this Evidence Code 1129. And with that, I will turn it back over to the mediators. And I thank you very much.
Thank you very much, Phyllis. Okay, we're going to take a small 2-minute break, and then we'll come back to have Adam Porter introduce our next speaker, Jeff Kichaven. Okay, hope everybody enjoyed that short break. And now turning over the program over to Adam Porter from the Beverly Hills Bar Association. Adam, take it away.
I am pleased to introduce my friend and colleague, Jeff Kichaven. Jeff has an independent mediation practice with offices in downtown Los Angeles. Previously, Jeff was a mediator with JAMS. Jeff has been a partner at 2 prominent Los Angeles law firms. Jeff has a bachelor's in economics from UC Berkeley and a JD from Harvard Law School. Jeff has won numerous awards as a neutral. Jeff has taught for the Harvard Negotiation Project and Pepperdine University School of Law. I now turn it over to Jeff.
Adam, thank you so much for that gracious and generous introduction. And thanks so much to the Beverly Hills Bar Association and the New York County Bar Association for sponsoring this excellent program. And what I want to talk about today are ethical, or really in another sense, moral issues that relate to mediation. And I particularly am happy to do this in a program sponsored by the Beverly Hills Bar Association, which was founded to combat discrimination in the practice of law. The Beverly Hills Bar Association was founded because the Los Angeles County Bar Association at that time wouldn't accept Jews as members. And so the Beverly Hills Bar Association in large part was formed to deal with that. Indeed, all of your Beverly Hills Bar Association representatives and several of your New York County Lawyers Association representatives would only have been eligible to join the Beverly Hills Bar Association the time it was founded and for many years thereafter. So what I want to do is talk about certain issues through the contemporary lens of race and to analyze how certain aspects of the mediation world, I think, ought to be viewed through that contemporary lens. In our preparatory comments, we had a lot of conversation by the emails among us about the implications of court-annexed mediation, more particularly in New York than in California. But it exists in both jurisdictions. And I think there's several challenges, problematic aspects with those programs when viewed through the contemporary lens of race. Mediators on these court-annexed panels tend to be more diverse. Why? Because they're going to be drawn from younger cohorts of the legal profession. And the younger cohorts of the legal profession tend to be more diverse than the older cohorts of the legal profession. So a group of new entrants into the mediation field, those more likely to be on these court-annexed panels, will tend to be more diverse. Mediators on those panels are being asked to work for free, for no pay, or for sub-market rates, for an unfair amount of compensation. It should take no more to recognize that this is a problem. We have a government program focused to a significant degree on women and people of color, asking them to work and not to get paid at all, or at least not to get paid fairly. The issue becomes more complicated when we ask ourselves, for whom are these younger mediators being asked to work for free? Well, let's take a look at the New York County Lawyers Association and the marketplace it serves. New York County, Manhattan, Southern District of New York, where corporate America litigates, where big business and big law take their cases to court. Big business and big law have diversity issues and challenges of their own. Let me just say, without putting too fine a point on it, that I have not heard too many people say that corporate America, big business, and big law are too diverse. So you have younger people, women, people of color, in a government program which requires them, I'm going to use the word, to be exploited in favor of clients who tend not to be women or people of color. I use the word exploitation with some care. Is it really exploitation, or is there something in it for these younger, more diverse mediators? In my judgment, and based on what I've observed in the marketplace for mediation services, I think there's very little. The pitch to the younger mediators is that if they give away these free samples, if you will, or work for free for a while, they will move up. They'll move up and they'll start getting paying cases. While I haven't done scientific or statistical analysis of this, I have certainly observed it for many, many years, at least since I was president of the Southern California Mediation Association in 2005. And what I've observed is at these lower levels, they should call the entry level of the mediation profession, there is a lot of churn. There's a lot of turnover of people. I noted this at our conferences for the Southern California Mediation Association, when every year I, or when I was president, or whoever was president at the time, Phyllis probably did it the year she was president, we ask at the conference, how many people are attending this conference for the first time? And every year, lots and lots of hands go up. Always seems to be around about half, again, based on a non-scientific observation. Well, it's nice that new people want to enter the field, but if we have half the people being new entrants every year, I ask myself, what happened to the people who raised their hand last year? Or what happened to the people who raised their hand 2 years ago? Did they stick? I don't think so. I think they went back to conventional law practices in large part, or to other opportunities and different sorts of careers. Why is that? Why have these people going through the court-annexed programs not been able to move up and stick with membership in the Southern California Mediation Association and perhaps other associations as well? Part of it, I think, is that we fool ourselves. We fool ourselves into looking at these court-annexed programs and giving the moniker pro bono to these programs. My friends, I don't think this is pro bono mediation at all. It's just free. Pro bono mediation, pro bono publico mediation, is mediation that you might do for a legal aid society or in a prison mediation program or in a community mediation program. Pro bono implies that you're doing it for people who couldn't otherwise afford it. But who are the people who are using these free mediation programs? We saw it here in California. You, I assume, see it in New York County as well. Big law firms, well-financed members of the plaintiff's bar, insurance companies, significant law firms. These people are not entitled to pro bono services. They can afford to pay mediators. And yet we apply the term pro bono to it. So here's what happens in my unscientific observation. People give away these free samples in the hope that it will lead to paying business. And it just doesn't. What happens is that the users don't call you back with paying business. Rather, when you get sick and tired of working for free and being exploited, the users of the free panel simply move on to next year's group of trainees, the people raising their hands, the first-time attendees at the Southern California Mediation Association conference in year N+1, whatever that year happens to be. In the meantime, who does corporate America hire? Who does big business hire to mediate the cases on which they're paying the big bucks, the market rates? They're mediators in many cases who have not worked their way up through the ranks. They're retired judges and retired partners from big law firms. Again, not America's most diverse cohort. So viewed, let me be direct, court-annexed mediation appears to me as a system that perpetuates hierarchy, patriarchy, and the status quo of power. What's the answer? What's the answer? First, we have to understand the real challenge, and let me go beyond challenge and say problem, which we face. And we all know this problem. There's just not enough mediation work to go around. Supply of mediation services far outstrips demand, and it always has. How did mediation come into existence? Mediation did not come into existence when a bunch of big law partners sat around a conference table or at a coffee house or bar. They did not go to a meeting and say, you know, we just can't get our cases settled. We just can't get them settled. I know. Let's invent a new profession of people to help us facilitate negotiations and get our cases settled. I don't believe such a meeting ever happened, either in the Southern District of New York, the Central District of California, or any place else in the United States of America. Rather, what happened is the supply side of the equation, us, we have always been chasing the demand side of the equation, trying to convince them and persuade them that there's real value and real merit from using our services and from compensating us fairly. There's a lot of work to do yet in that arena, my friends. Indeed, the fact that so many of us think it's a good idea to rely on court systems to compel people and coerce people and order people to mediate is itself an indicator of just how much more work there is for us to do in the world of mediation. Because if what we were doing was really that valuable and perceived to be that valuable by our users, we wouldn't require courts to order and compel and coerce people to use us. So the sad truth is that among all the new entrants, the idealistic people coming into the mediation field, very few of them are going to succeed. The demand side is just not providing enough work for everybody. Well, what's better? How can we allow people, younger people, to move up properly in the field of mediation? I think we're better off letting people compete on price. I think that competition based on price really is the key. How come? Because the key, and again, in my unscientific observation, the key to people moving up in the mediation field is that mediators must be available on short notice when the person one rung up from the food chain from them is not available to handle somebody's case. It's very difficult to make yourself available on that basis if you have a mixed mediation litigation practice. The litigation practice clutters up your calendar. There are court appearances, there are depositions, there are briefing deadlines. And if somebody calls you up with a last minute mediation, it's very difficult to say, oh yeah, hang on, let me just call the judge and put off that hearing next Tuesday so I can handle your mediation. That request to a court's not going to go over very well. A deposition that's been scheduled for a long, let me just call opposing counsel and ask them to kick that a couple of weeks so I can handle your mediation. Again, that's not likely. So to move up, younger mediators must have their schedules open. But when your schedule is clogged like that, you can't do it. And it's very difficult just to ditch the mediation practice and say, okay, I'm going to keep my schedule open. If you're being asked to work for free as a mediator, or if you're not being compensated fairly for your services, this is why I emphasize competition based on price is so critical. If you're compensated fairly for your mediation services, then perhaps you can afford to plant that flag and burn the ships behind you and say, today I am a mediator and that's all I am. And then set yourself to work wholeheartedly on that. So my judgment is that we must abandon the idea of court-annexed mediation as some sort of future or hopeful scene for mediators to move up and for us to diversify the mediation profession or field appropriately. It's wonderful that we have trade associations like the New York County Lawyers Association, like the Beverly Hills Bar Association, like the Southern California Mediation Association and others, to put together lists of mediators, rosters, to allow people to publicize that they're in the field, they have planted the flag, and what their prices are, so that potential users can find the right mediator, not only based on the right expertise and experience, also on the right price to get the job done. My friends, I thank you.
Jeff, thank you very much. And we're now going to go to our final speaker of the day. I'm going to introduce my colleague, co-chair Chris Fladgate, to have an introduction for Cynthia Boyce. Chris, take it away.
Thank you, Alan. It is my pleasure to introduce Cynthia Boyce. Cynthia is a graduate of Harvard Law School and Wharton Graduate School, where she finished her MBA. Cynthia has, as do all of our panelists, a tremendous amount of ADR experience, having mediated a large variety of cases, including but not limited to employment, discrimination, ADA, Section 1983, commercial, contract, real estate, foreclosure, construction, bankruptcy, visual art, and family. And she participates on many state and federal court mediation panels, as well as the International Institute for Conflict Prevention and Resolutions Employment panel. She's also mediated in the past for the American Arbitration Association, the United States Postal Service, and FINRA. As for her arbitration experience, Cynthia is currently part of the American Arbitration Association's Commercial Arbitration Panel and was an active arbitrator for FINRA and the American Stock Exchange. Cynthia is also a practicing attorney who has represented clients in a variety of matters, including but not limited to discrimination, contract negotiations and disputes, business formation and disputes, visual art businesses, nonprofit formation and management, as well as real estate. She'll be speaking to us today on the ethical issues in New York mediations. I'd like to introduce and offer a warm welcome to Cynthia.
Thank you. Hello, everyone. And Jeff, that was quite a provocative discussion. And I will actually be touching on some of the things that you've mentioned, just going about it a little differently. So just to start, yes, I'm going to be talking about ethics in New York, and our next slide. So we are going to be looking, I call it our game plan, is to look at the governing documents and relevant influences. And there are 3 topics that I've selected just sort of based on what's going on in New York in the mediation field, and that's implicit bias, compensation, which I think Jeff covered in a very interesting way. I'll present it slightly differently, and inclusion. Next. So governing documents for ethics, model standards of conduct for mediators, and you can see it's been adopted. All these are national organizations. It's dated 2005, and it's in your materials. Next slide. There's also the New York Rules of Professional Conduct, effective in 2009, and this governs attorneys practicing in New York. I'm not focusing on this, but I just wanted to mention there is actually, what is this? It's a ruling from the New York State Bar Association, Rule 1178 in 2019, that essentially says that if you are an attorney who is practicing mediation, then these rules do not apply to your mediation practice. I think there's some controversy regarding that. So if we want to discuss it with in questions, we can. Next slide. So Stephen mentioned presumptive ADR, and that's one major area of influence, and that has a lot to do with shaping the areas that we'll be discussing today. So, and the other is focus on equal justice throughout New York State court system, including the court annexed ADR. Next. So, New York presumptive ADR. This was a goal of Judge DeFori, our chief judge in New York State courts, change the culture from litigation first to mediation first. So, Jeff, we are trying to increase the demand. It was effective approximately in September 2019, and it's a system-wide initiative. So here, civil cases are referred to mediation or some other form of ADR, which here I like to call it appropriate dispute resolution. Many say alternative, but I say what's most appropriate. And the first step in the proceeding should be, or as early as possible in the case, should be dispute resolution as opposed to litigation. And this is also in your materials, the press release describing this, and then the ADR committee's interim report. Next. So these are the based on the national recognized ethical guidelines. I've listed them. Confidentiality, we've certainly had quite a lot on that from Stephen in New York and from Phyllis from California. And these are the other areas, and I've highlighted the ones that I'll be discussing. Next, please. So there's a New York statewide ADR advisory committee. And this is the committee that developed the recommendations that led to the presumptive ADR that Stephen mentioned and I also discussed. And the appointments were by our chief judge, and they are in the process. We talked about having at least one document that covers New York. They're in the process of developing a New York State Unified Court System Mediator Standards of Conduct. And so I joined this, I was appointed to this committee in June of this year. And I thought, oh, great, I'm doing a program on ethics. I can show a draft of this, of these standards. No, I cannot. They're not ready for distribution. So next slide, please. The other area that is really big with the advisory committee and also is being discussed, and as you can see from Jeff, focus on equal justice. And so the judge actually asked Charles Johnson and his firm to prepare a report from, they prepared a report from the Special Advisor on Equal Justice in the state courts. It's dated October of 2020. And the goal was to conduct a review of racial bias in New York state court system. So Jeff, I'm handling race too. And no surprise, found a lack of diversity in the court system and in effect, a second-class system of justice for people of color in New York State exists. So the ADR Advisory Committee is also focusing on equal justice. My comment is that I think we should say equitable justice. And you can, I'm sure many of you have seen a picture like this before where it's not a matter of giving everyone the same thing, but having everyone end up at the same place. And that may mean different things for different people. So next slide. So talking about bias, there's explicit bias. You know, person's very clear about their feelings, their attitudes. It's processed neurologically at a very conscious level. People know what they're thinking. They can express it in words. It's often characterized by overt negative behavior and expressed through physical or verbal harassment. And so basically, and can be lead to exclusion. Next. So this is a obvious example of explicit bias. They've tried to find, this group found as many ways as they could to show bias. And so we know that, well, go to the next slide. And this is based on something that happened to me. I traveled a lot throughout Asia. And so I was actually on the plane on my way to, I'm not going to mention the country, where I was going to do some work and, you know, be very active in some projects there. And a very nice white gentleman was sitting next to me and we started talking and he said, oh my gosh, you're going there? Well, they are sexist and they do not like African Americans. I said, oh, well, I can't change being a woman, don't want to. And I've always been an African American, so this is what they're gonna get, African American woman. And so I was there working for a while and, you know, I did not detect any racism. And after making friends, I finally turned to some of the group and I said, you know, this is what this guy told me. And, you know, gee, I don't feel any racism toward me. And they said, oh, it's not you, it's the Vietnamese that we hate. So racism is racism. So next slide. So that is also, I believe, very explicit. Now we get to implicit. And most of us have heard about implicit bias, but I want to bring it to your attention because this operates outside a person's awareness. So as mediators, we are not necessarily aware of our implicit biases. They can be in contradiction to your espoused beliefs and values. and it seeps into your behavior, and it's often outside of the full awareness of the person. So you may not have conscious or internal control. Next slide. This just shows that the test, one of the implicit test that has been developed, and there you are often asked to associate white, if it's a racial test, you associate, how fast can you associate white with bad or black with good, and vice versa. Next. So now let's look at the standards. A mediator shall decline a mediation if the mediator cannot conduct it in an impartial manner. And impartiality means freedom from favoritism, bias, or prejudice. And of course, we should not act with partiality or prejudice. And if at any time a mediator is unable to conduct a mediation in an impartial manner, the mediator shall withdraw. Next, please. So the question is, what's our duty as mediators with respect to implicit bias? With respect to bias, we know if we're, if we have a bias on, if I were to make a statement, no, I hate the Vietnamese, obviously I would not mediate I should not mediate where there's anyone from Vietnam there. But should we have a duty to identify or be aware of our implicit biases? And can we control for, or should we control for implicit bias? Next. So there is a test, and let me just get my notes, implicit association test. And this is I illustrated a little bit of it before, and now it's I think started off with race. Well, actually, it started off with, I think, fruit or insects and flowers, just to see how it worked. But it then went on to looking at sexuality, gender, and a number of things that where we could have implicit biases. And I have them listed there. So one, it allows you to see what types of biases you have that you may not, about which you may not be aware. But here's the thing, I've had implicit bias training, not the full training, but I've certainly taken workshops to help identify. My time is running out. So one of the individual who founded implicit association test said that there really is no, first of all, it's pervasive. When you look at all Americans, 70 to 75% were found to have some sort of implicit bias. And actually for white Americans, it's a greater number. White and Asian Americans, it's a greater number than for mixed race and African Americans. And for African Americans, they're basically neutral. Next. So this is just some other resources that people may want to read on looking at how to avoid being racist, actually being anti-racist. And so I'll leave that. I mean, we can move to the next one. The next standard is how basically conflicts of interest. And I'm not going to read the whole thing. The key here is that you want to assure that you have impartiality. And a mediator should disclose as soon as practical actual or potential conflicts. So that could be raised around impartiality. And so if you have implicit bias, next slide, please. Routinely mediators do conflicts of interest. The question is whether or not we should also do a conflict of interest regarding our impartiality, our implicit bias. And is there an ongoing duty to monitor that? Next. Competence, cultural understandings. That's another one of the standards. And again, looking at, do you understand, are you competent to be able to deal with another culture? And do you have any biases there? Next. Quality of process. This one looks at racism and bias during the process. Next. So there are the parties culturally insensitive? Are there indications of bias by one or more parties? And does this impact the quality of the process? I just put in here, I'm paraphrasing, but in an FLSA case, an employer says, I can't believe they're suing me. I treat them like family. They have the key to our home and they eat with us. And the employee, undocumented resident, in his own native language says, the employer gives me a key so I can clean the house when the family's away. I eat in the kitchen, at the kitchen table when they're done or away, and he does not pay me for overtime. So there's a disconnect there from a bias and also from a cultural standpoint. Next. And then there's, this is advancement of mediation process. So this is another standard. Basically, mediators should demonstrate respect for differing points of view. Next. So what does that mean? And I wanted to touch on a few things. Oops, I have no time. So if I can have a couple more minutes, I think I can get through this.
Take another minute.
Yeah, that's okay.
Thank you. So under presumptive ADR, and Jeff talked a lot about coordinates, but with presumptive ADR, it just raises the bar differently. And the administrators, everyone involved in the court have a duty to assure diversity of their rosters. And so, and there are three models, because it's not just diversity of the roster. And in our rosters, I don't think, as you mentioned, Jeff, that they were, there tend to be younger mediators and mediators of color. That is not what we are seeing from my perspective in New York. There are middle-aged white men are the majority. So the models are the administrator can select the mediator, attorneys can select, or there can be a hybrid. Basically, if the parties need help, the administrator will select. And this diversity is consistent with the goals of the ADR Advisory Committee. And so, you know, and I say there should be a broad view of diversity and also looking at lived experiences. You know, it's not just the diversity in terms of your race or culture, but what have you experienced in life? And so, and then the federal courts, the Eastern District of New York, generally the attorneys select unless they can't, and then the administrator will step in. And then a Southern District, the administrator selects. Next. So we get to fees. This is basically the standard for fees, and you can read this. It's basically you as a mediator get to make your own determination, or you should make sure you notify the parties of fees. If it's state court annexed mediation, then under presumptive ADR, the court gives guidelines on fees. So one of the key things is that, and this definitely goes to what Jeff was discussing, preparation time free of charge for all state court annexed mediations. And then they all require some portion of the mediation session to be free of charge. It goes from 90 minutes to 3 hours. And that is because they believe that without legislation, they cannot send someone to mediation and then tell them that they have to pay. Next. So in contrast, the federal courts, the Eastern District, preparation is unpaid. The meter starts when the mediation session starts. And there it is not at market rate, definitely not. But you do get paid. And then panel members are required to volunteer for pro bono. And this is real pro bono, as Jeff mentioned. And those are cases where at least one party really cannot afford the mediation. And often they are assigned an attorney to represent them free of charge. The Southern District, it is totally unpaid. But there again, remember, it's the administrator that decides that appoints the mediator. Next. So I just asked what's fair for the parties to process. Yep, and there should be one more slide. That slide's not there. I did cover everything. Okay, I got through it. So I did not include my email and phone number there, but it's in the materials that you received. And thank you. And I look forward to questions. And
All right, well, thank you very much, Cynthia. And by the way, you could put that in the chat during our next 2-minute break, which we're going to start right now. We're going to have a 2-minute break, and we're going to come back with some questions. That's going to be our roundtable portion, where the moderators are going to ask the various esteemed panelists some questions. And just so everybody knows, I do see that there are some questions from the audience. So we do have 10 questions which were set out. We're necessarily not going to get through all of those, but what we're going to do is I think I'm going to have each of the moderators have each of their questions assigned to them. We're going to alternate between New York and California. And then what will happen is that we will then go to the audience questions after the fifth moderator that we have. So we'll see everybody back in 1 minute and 26 seconds. And we're back from our break. Just a quick note on timing for everybody who's wondering about the time. We're going to set about 50 minutes, 50 for the roundtable. It's NYCLA custom that if we have questions that have gone over from the time, either that people want to discuss or just they're coming from the audience as we go along, we have what's called an after party, meaning we stay, another 15, 20 minutes, whatever it is for, and any of the panelists, of course, they have to go. They can go when the program concludes, and same with all the attendees. But you're welcome to stay for the after party time as well, so you can see if any of your questions get answered. But again, we're going to be going now to the roundtable, where each of the moderators will have their questions, 1, 2, 3, 4, 5, and then we will turn to audience questions. And then if we have further questions that we can get from our list, we'll get to them. So without further ado, I'm going to jump off right where Cynthia basically left off. And that's with the topic of mediator compensation, which Jeff spoke about as well. So first dibs on this probably should be given to our other panelists, to Stephen and Phyllis, to get their views. We certainly heard something from Jeff about this, and then a little bit from Cynthia. Maybe she wants to comment more. Here's the question. There's been much discussion in NYCLA ADR committee meetings, mediators meeting online meetings. That's a program that Nelson and I run every Tuesday, where we have mediators from all over the world attending Zoom meetings, coming together, as well as meetings of the ADR committees of sister bar associations regarding mediator compensation and the Office of Court Administrations, that's New York's position that a minimum amount of free mediation session time, Cynthia just spoke about, usually 90 minutes, go up to 3 hours, must be given to parties on the basis that in the absence of a statute, there's no legal basis to compel parties to pay for mediation services, and it's exactly what Cynthia just mentioned. In fact, there was even an informal meeting that I ran on May 4th, 2021 on Zoom, in which Jeff participated, dedicated solely to this topic. This position of requiring a certain amount of free time in mediation has been taken notwithstanding the many hours that mediators must spend in preparation in advance of mediation sessions, and the fact that federal mediation programs, as we've heard, provide for mediators to receive guaranteed minimum compensation, albeit not at market rates. What are the panelists' views on this type of free time mediation compensation system, which, based upon my research, applies to at least a limited extent in California as well as in New York? And in answering this question, please also feel free to address your views as to whether a free time mediation system will advance or hinder state court presumptive mandatory mediation objectives, as well as whether such a system will advance or hinder achieving diversity in pools of neutrals participating in court annex mediation programs. So we'll ask, I guess, Stephen to start off on this one.
Gosh, that's quite a mouthful there. I first of all, I really appreciated Jeff's comments about this issue. I thought they were really, really fascinating and well thought through. I don't know that I'm in 100% agreement with them. I think mediators should be paid for their services. And there's something that rubs me wrong about a mediator, whatever that mediator's level, not being compensated for her or his services. I've done a lot of work in the world of employment law, and it's just not okay to not pay people for their work. But we do have this thing known as pro bono in the legal profession. And so are mediators through the court programs really providing pro bono services? Maybe in some circumstances, but I think, as Jeff pointed out, with respect to particularly the Southern District of New York, probably not in a lot of other circumstances, given the litigants and the law firms that are involved. So all in all, I think mediators should be paid for their services, and it does rub me wrong that they're not, even in those programs. But here's the thing that I have struggled with for years, and I continue to struggle with. I do believe that these programs provide opportunities for some mediators who do not have much experience to get experience. And I'm not convinced that the data or the evidence is such that that doesn't happen. It happened for me. That might be part of the problem why I'm in conflict, because it did happen for me. When I started mediating cases through the federal court programs, I didn't have a lot of experience formally mediating cases, and I gained a lot of experience through those programs, and that was valuable for me. If I had to choose, absolutely. If it's binary, I would say, yeah, all mediators should be paid for their services. If I could carve some type of exception in there for individuals who are more in the starting out frame of reference to get the experience that will benefit them for some initial period of time, perhaps I would carve out some exception. That's my reaction.
Well, thank you very much. And now we'll take it over to Phyllis, since it's her first time. Go ahead.
While I'm all for providing mediation services for those who truly cannot pay, I find that in the majority of instances, people can pay and are simply gaming the system. There is a California appellate decision called Gelwin versus Superior Court, in which the appellate court held that mediation is confidential and is voluntary, rather, and you cannot force people to pay. And because of that appellate decision, a state court judge is loath to order people to private mediation or to force them to pay, because it goes directly contrary to this appellate court decision. I'm also a member of the U.S. District Court panel for the Central District of California, and we are to provide 3 hours of pro bono services before we can charge. Unfortunately, the Central District has the largest caseload of all of the district courts in the country, and it is particularly burdened with American with Disability Act cases, and we have a bunch of professional plaintiffs. I think one plaintiff has over 600 cases alone. It's how they make their living, and we all, when us panelists get together, we all sit around and complain about these plaintiffs' attorneys who will go to the 2 hour and 59-minute mark and then walk out of the mediation so that they don't have to pay. And I had one mediation right when the pandemic started, where they sued a tenant who was out of business because of COVID. They sued the landlord who was about to be foreclosed upon, and he insisted on getting paid. And at one point he said to me, well, I'm not a charitable organization. I insist on being paid. And here I was providing 3 hours of free services. The upshot is, I think I agree for pro bono when people really need it, but I think it's being horribly abused. I agree with Steve that it's good to get for young mediators to get experience, but I don't know how. But I also agree with Jeff that they'll use you for free, but seldom will they come back and pay you. They'll just go to another free mediator, particularly with the American with Disability Act cases. But because of that state court appellate decision, at least the state courts here are in a bind where they can't force people to pay for mediation. And so I guess I pretty much like Stephen, where I'm sort of conflicted. It's great, in California, they started free mediation in the 1980s to get people to sign on to it, just like the person out on the sidewalk giving away free samples of a product, to build up a market share. But I think the time has long passed for us to be giving out samples unless it's to people who truly cannot afford it.
Good. believe Cynthia has a comment to go for that. We're going to hear from Cynthia. I know Jeff spoke about this extensively, so we're going to excuse him from this one. So Cynthia, please respond, and then we're going to go to our next question.
Yeah, a couple really quick things. One, this is actually in response to something that Jeff said about supply. With the presumptive ADR, the prediction is that the demand will be increased greatly, and so that we need to increase the supply. With regard to what Stephen said about getting experience through the pro bono process, one of the issues with that is that you've got to be able to afford to do that work for pro bono. So that limits the people who really can do it. I mean, I started off doing pro bono work not in court, but in the community development, the community programs, and did that for free. And I got a lot of experience and skills that, I had to manage my practice so that I could, do that plus work. And the final thing is the Southern District. Stephen and I both know the administrator, and she will tell you the reason that she has it as non-paid is so one of the benefits is so that it's a random selection of the administrator. So everybody on the panel actually gets an opportunity to mediate, and you can take as many cases as you like. So from a diversity standpoint, she thinks that is a benefit. But I also get that through some state court administrators where you do get paid, and they will be the administrator, and then you get paid after the 90 minutes. So thank you.
Thank you very much. All right, we're now turn the next question over to Glenn, who's going to ask a question regarding changes to courts and court administration policies. Glenn, take it away.
Thanks, Elon. I'm going to combine a couple of my questions here to the panelists. This question is, of all the changes to the courts and court administration policies since the pandemic commenced, which do you think are temporary and which do you think will become permanent? And the second question was, in terms of online dispute resolution, which obviously is, a piece of this, what particular elements have you found surprising that possibly you didn't expect? I will note, just on my own, as I'll just count myself among the panel members here for a moment. Here in the Los Angeles area, the LA Superior Court just recommenced a personal injury settlement program that had been an in-person, effectively a mediated type of program, although it was more like a collaborative law session where one lawyer would take the side of the plaintiffs, another lawyer experienced in personal injury law would take the side of the defendant, and they would jointly try to resolve the case. That particular program, of course, when the pandemic hit, became untenable. And so with the participation of two plaintiff PI bar associations and the defense PI bar, and with the participation of the Beverly Hills Bar Foundation, over my objections, I might note, they just established an online PI settlement program where these mediations or settlement processes would go forward on a Zoom basis. Again, pro bono, or as Jeff would probably say, for free, as opposed to not necessarily in the public interest. So with that, I'll turn it over to Jeff, who I'm going to suspect has some pithy comments to make on this particular subject himself.
Thank you, Glenn. I was happy to note when reading about this new program that it is not called a mediation program, it's called a settlement program. And the people doing the work in that program are not called mediators, they have some other title. So your efforts were not entirely in vain. I want to just ask about this concept of the court administrators assigning or giving mediation tasks out at random. The administrator gets paid, right? The administrator is paid. Okay, so that's an interesting point. And I guess, I think maybe you're really onto something here of having a government bureaucracy decide which professionals will work on a client's case. I think maybe you just haven't taken it far enough. How about if this also applied to expert witnesses? Well, we all know that an expert witness is just a person from out of town with a briefcase, right? And they generally cancel each other out and they talk in technical mumbo jumbo. Nobody understands them anyway. So why not just have a panel of expert witnesses and have a court administrator at random say which expert witness will work on which case for free? How about that? And actually, let's really put the frosting on the cake, Glenn. Let's have it apply to lawyers too. Why don't we have a court administrator decide which lawyer represents a client on a case? I mean, if a court administrator knows better than the parties themselves which mediator to have, and that's a very intimate relationship, why not have a court administrator decide which lawyers work on a case and compel those lawyers to work for free too? Because what is more important to the administration of justice than the lawyers? If you think mediators should work for free because of what we contribute to unloading the burdens of the court system and aiding the administration of justice, certainly lawyers, what they do is even more important. Because can you imagine a court system where there were no lawyers representing clients, nobody framing issues and making it easier for judges to decide those properly legally framed issues? So I think that you can tell that these are facetious suggestions, and I'm using the logical technique of reduction to absurdity to counter the argument. And in fact, the selection of the mediator should not be at random, and the selection of a mediator should not be done by a government employee in the courthouse. Because what we do in mediation relates so much to the relationships between lawyers and their own clients, helping lawyers whose clients may have unrealistic expectations. That's one of the most important things we do as mediators. And what does a court administrator or a judge know about the nature of the relationship between a lawyer and their own client, and which mediator is best suited by expertise, temperament, or otherwise to be able to get on wavelength with the clients and with their lawyers? The people who are in the best position to decide not only the timing of mediation, but also the selection of the mediator are the lawyers themselves, the ones who know their clients, the ones who understand their client's emotional state and can get a sense from talking to us in advance of which mediator is best suited to help these particular people in that particular case. I hope this helps.
Jeff, thank you very much for your comments. I know Harvard Law is very proud of its prestigious graduate who uses all of his well-learned advocacy skills.
and my alumna sister Cynthia as well. Happy to have that, be able to start a friendship with you here, Cynthia.
Stephen, would you like to comment?
Yeah, I'd like to make a quick comment.
Ahead,
One of the downfalls of having attorneys pick mediators is that they tend to pick people who look like them or people they know. So there's where the diversity issue really doesn't get the same kind of opportunity as where there is either a random or administrator who selects based on the expertise of the mediator.
Stephen, anything to add? Comments?
Not on this particular topic. Thank you.
Sure. Phyllis?
Not on that particular topic, but Glenn, you also raised the question about online dispute resolution. And I really think that it is here to stay if and when we are no longer in a lockdown or a pandemic situation. I attended a meeting of the U.S. District Court panel the other day, and I also got a report from the National Association of Neutrals, of which I'm a member, and I think both indicate that many mediators believe that online dispute resolution is here, that people will want to continue to use Zoom to mediate, even after in-person mediations are given the go-ahead. It's a lot more convenient. They tend to be more efficient. People tend to be more civil. And you will have, I think, higher management showing up because suddenly they don't have to get on an airplane and fly across the country. They just have to hit the Zoom link. And so you'll have more of the true decision makers attending these mediations. And that's the only point I'd like to make.
Glenn, could I amplify on that for a moment, please?
Sure, go ahead, Jeff.
I think that what I'm starting to see is that people from insurance companies are not getting on airplanes to come to mediations anymore. They're just not going to do it. So I've had several situations in the last many weeks where local people have said, we'd like to mediate in person, and can we establish a set of cleanliness and hygiene protocols to do that? And I say, sure, we can work something out. And then the people from the insurance company say, look, we're not sending somebody on an airplane from Chicago or New York or Hartford to come to your mediation. And since we can't be there in person, we don't think it's right that you're there in person with everybody else chatting behind our backs, and we're excluded from these channels of communication. We think it will work against us. So since we can't be there in person, we don't want anybody there in person. And since we've now established this default over the last year and a half or so, that online mediations work pretty well, I'm honoring that request, and I think other mediators will too. So particularly where we have people from around the country, insurance representatives, the top management that Phyllis mentioned, we would all love to have in person at our mediations. I think we're going to be doing them strictly online in many, many cases for a long, long time to come.
That's really interesting. I have not yet had that situation arise where, whether it's an insurance carrier or someone who's very influential with respect to what the outcome of the mediation is going to be, say, well, you know, I can't be there in person, so nobody should be there in person. That hasn't happened to me yet, though it may very well happen. I have had attorneys say to me that when the pandemic is over, that they don't ever intend to do this in person. And I've had a few attorneys say that to me. That may change. We'll see. You know, if you had asked me about 2 weeks ago, no, I'm sorry. If you had asked me, say on March 1st of last year, what my opinion was of doing mediations by video conference, I would have said that's nuts. That is not going to work. That just cuts against some of the most fundamental aspects of the relationship between a mediator and the people who are in the mediation. And then a little bit after March 1st, until about 2 weeks ago, I did not mediate a single case in person. And I mediated many cases by video conference. And the surprising thing to me is not only that it works, not only that I can do it, not only that the participants are okay with it. In fact, some are enthusiastic about it. But the most surprising thing to me is that, though it's not an absolutely scientific study, from everything I can tell, my rate of success in these mediations, if success is defined as reaching a resolution, it's no different. I believe that as many of these matters that I mediate get resolved or don't get resolved through video conference as did before video conference. And that's pretty striking to me. I do still believe that there are some disputes that are highly emotional, and it might be, for example, in an employment context, harassment cases, discrimination, retaliation. I think there are some disputes that by their nature are highly emotional and would benefit from in-person mediation. And I think those cases, once things normalize a bit, I think those cases will tend to gravitate towards in-person mediation. But video conference, it's here to stay.
Yeah, I must say, just to add my own comments, that my experience has mirrored Stephen's almost exactly. I've never had a situation as Jeff described, but I was very reluctant to allow participants to be part of my mediations by teleconference prior to the pandemic, both for my feeling that you had to have skin in the game, and so forcing people to be there in person was important for their investment in the mediation. And then, of course, we all talk about nonverbal communication that you can really only get at best, in the best sense, when you're in person with somebody in the same room. But my Zoom mediations have been surprisingly effective. I think I've got 100% with one case outstanding still during the pandemic. So that's been somewhat surprising to me. So time to move on to the next question. I'll turn it back to Elon.
Yes, all right. And our next question is going to be asked by Nelson. Nelson, please ask question 2 on local ADR rules versus state uniform rules. Go ahead.
Okay. In New York, we don't have a system of statewide uniform ADR rules or procedures such that there are tens, if not hundreds, of sets of local ADR rules and procedures that neutrals must master. Is California different in this regard? And irrespective of whether it is or not, what are your thoughts on having at least a foundational set of statewide ADR rules or procedures for court-annexed ADR programs that can be supplemented as necessary with specific local rules as necessary? That's a mouthful.
Well, I can take that one. California definitely has the uniform rules of court. If you look at rules 3.850 at SEC, they more or less parrot the model standards of conduct for mediators and apply them to court-connected mediations. And so there is a uniform set of rules in California that should be applied in all 57 counties. Whether or not they are in fact applied is a different story.
Okay. Let's see, Jeff, you want to comment on this issue, or?
Oh, Elon, I'm not on any of these court annexed panels. Just this mishmash of rules is just another reason that speaks against them. The day that I signed off all of these court annexed panels, oh, what a weight off me it was. It was a turning point in my career as a mediator, and I've never looked back.
Oh, well, what about using then a uniform state-wide system of rules for the private providers in the specific jurisdictions? What about that?
We are an alternative system of dispute resolution. We should try to maintain that alternative status. The more integrated we are with the court system, the more the court system will want to regulate us in terms of what we charge, what the confidentiality rules are, how we conduct mediations, and everything else. So the fewer rules, people should just get off this idea that greater involvement with the court system is somehow good for us as mediators or good for the clients who we serve.
If I could just follow up with something, Jeff. In California, do you guys have different standards for how much free time you have to give in each of the different counties or cities, the way we do here in New York?
Yes.
And what about that? I mean, would it be easier if there was just one standard so that, say, you had to give, 2 hours of free time or 90 minutes of free time in each case? Or
No, I mean, when LA Superior Court had a pro bono panel, that was 3 hours. However, the appellate court for Los Angeles, I think, required at 1.6 hours. They may have cut it down to 4. The federal courts for the Central District requires 3. I did some pro bono for the Riverside County Superior Court, and initially they did not set a time limit. But because I sort of got caught up in an all-day mediation, they've now set a time limit for 3 hours. I think essentially 3 hours is sort of the going standard, at least maybe in Southern California. Orange County, maybe 2 hours, I think. I'm not sure. but 2 to 3 hours, I think, is the going standard. I don't think it needs to be uniform. It's simply a question of whether the mediator wants to sign on to that type of thing. And if they don't want to, then they don't sign up to do a free mediation.
Yeah, I think for whatever it's worth, Phyllis, you'll correct me if I'm wrong, but the 6 hours included 2 hours of prep time.
Correct.
Which usually took me about a half an hour at the most. And then it was 4 hours of active mediation time. But that being said, that's still 4 hours instead of 3 hours. Our current approved mediator panel at the mediation section sponsors through the Beverly Hills Bar is 2 free hours, but only for cases of a jurisdictional amount, $25,000 and below. But that's not court annex. That's our approved mediator panel. That's a private panel out of the Beverly Hills Bar.
So by the way, let me just, before I hand it over to Stephen and Cynthia, there are other aspects of the rules in New York. For example, communications between the justice and Supreme Court and the assigned mediator is different, let's say, between New York County and Nassau County. In New York County, it's prohibited. Everything in terms of communications has to go through the ADR administrator or the coordinator assigned to the case, whereas in Nassau County, the mediator is actually allowed, and in certain cases has to, depending upon certain events, to communicate with the justice. So in that lens, I mean, you don't have to only speak about free time and what else in the amount of time. Stephen and Cynthia, what are your thoughts about a uniform system of court rules for New York?
Well, as I mentioned, the ADR Advisory Committee is working on uniform rules of conduct for mediators. That's not ready for display, but those will be uniform, basically, and also some, there'll be uniform rules. And so we are working, now that I'm part of it, we're now working on that. With respect to the hodgepodge of how many hours and prep time, everybody says prep time is free. And I actually do a lot of prep. So I just I give as much prep time for court annex as I do to private, based on what the case needs. But yeah, I think it would be easier if you knew for each for New York, you'd say if it's court annex, it's X amount of time that you give that's free. And then after that, the clock starts, the meter starts.
If we're talking about court annex programs and mediations through those in New York, then the idea that there would be a common set of procedures or rules, the Northern District, the Southern District, New York State courts, well, geez, if I saw that in my lifetime, it would be absolutely amazing. I don't expect that will ever happen, at least not in my lifetime. But if we're talking about a common set of rules for everyone, for all mediators, and if we're focusing on, for example, ethics, confidentiality, then that's something I think is a worthy goal. If we're talking about a set of rules that somehow emanate from the courts that are not ethically based or confidentiality based, not grounded on like rules of professional conduct, for example, that apply to all practicing lawyers. If it's something beyond that, that goes into the practice of mediation, and if it's going to address the private sector, I'm all with what Jeff said. I don't particularly see the need for having those kinds of that kind of management of the private sector in mediation.
Okay, I think that does it for that question. And we're going to now turn the next question over to our California side, to Adam, to ask a question regarding, we did one with the surprises, so question 5. Adam, why don't you take that one away? Trials. Adam, you're on mute.
Apologize for my my eyesight as well.
I'm
Do you
gonna,
believe the general lack or current unavailability of trials has affected the ability to dispose of cases with ADR?
All right, let's open. Anybody wants to take it?
Phyllis, do you wish to comment?
I would say yes and no. Because of the court delay, some want to get rid of the cases and get the cases settled. On the other hand, some welcome the delay and, is willing to, particularly on the defense side, and is willing to sit there, until they're pushed to do something via a trial date. So I think it cuts both ways.
With many PI cases, they traditionally did not settle until you were literally at the point of trial. And so if you don't have trials being churned out, then there's no immediacy to the situation that helps you to settle a case in that area. So I think that is one area where a lot of the carriers would just as soon hold on to their money.
Jeff, do you wish to weigh in?
Adam, I'm going to say pass and hope that in contrast to my experience at Harvard Law School, I can get away with it.
You may.
Yeah, thank you.
Stephen, do you wish to weigh in?
No, I think that the amount of time it takes to get to trial, and again, my focus tends to be in employment, in the employment sector, employment litigation or pre-litigation. The amount of time it takes to get to trial has always been a factor for discussion in both rooms, with both the employer and the employee side. For the employer, it's often expense, years of litigation, uncertainty, and that's often a factor that is of importance in the employer room. And in the employee room, it's the delay in getting to a point of justice, and the delay in getting to a point of from the employee's perspective, hopefully prevailing and getting something out of the litigation. Further delay, the amount of time it's taking for matters to ultimately get to a trial, or when people hope that they'll get to a trial, which is even greater now, it just makes those discussions in each of those rooms more powerful from my perspective, and gives me as a mediator some important things to talk about in each room and to underscore the impact of that delay. It's not one-sided. It's not as if it's not as if it's super helpful to one side in the kind of disputes I mediate, and not helpful to the other. It's somewhat even.
Thank you, Stephen.
Okay, and our last moderator-based question is going to go to Chris Flodgate. Chris,
Hi, this is something Jeff touched on before from the California perspective, so I'd be interested in Cynthia and Stephen's views from the New York perspective, which is how are ADR coordinators and administrators guided in choosing mediators in New York, and how should they be guided? Related to that, do and should the judges or parties have input in the neutral selection process, and if so, to what extent?
Cynthia.
Oh.
Well, I'd love to hear your thoughts.
Well, at this point, the administrators talk with you and have an understanding of what your style is and your areas of expertise. And if they're the ones that are, I know Jeff doesn't like this, but if they're the ones that are assigning, then they will select someone based on the fit for the case as they see it. Now, the parties always have an opportunity to say, no, I don't want this person. And so that can absolutely happen. And both parties, have either party can say, no, this administrator, this mediator, for whatever reason, is not, we don't agree. And you get to do a conflict of interest, which is what I was talking about. You have to see whether or not you think that you're competent and there are any conflicts. So that's really, that's how they decide. And they also look for diversity. So they will see whether or not the people on the panel are being used, and especially if those people don't look like most of the attorneys who bring the case. So that, but first they're going to make sure that you fit, your expertise fits what they need. And then they give women and people of color an opportunity that you don't necessarily get when the attorneys are white male and don't know you. And so, and you know, I do get cases now because administrators say, oh, we know Cynthia, we know that she's able to handle these cases. And then some of the parties do contact me on their own to have me do cases. So I think it's a very useful tool to have administrators assist in assigning.
I think that the outcome of that that setup depends on the quality of the administrator. If it's and the premise of the selection process. What I mean is that, you know, I can think of 3 panels that I have been on, court panels, and in one, the premise appeared to me to be that the administrator would simply decide which mediator was going to get any particular assignment. In another, the premise seemed to be it's the parties who get to select. There's some selection by the administrator, perhaps for mediators who are not yet known in the community, but by and large, the premise in this other system that I'm thinking of is the parties get to choose. And if the mediator wants to mediate in response to the request, then it goes forward. And in the third panel I'm thinking of, it's a random selection process with the administrator having an active role in it not always being random for various reasons. And in a lot of these cases, it comes down to, in my opinion, the type of person who is the administrator and how that person approaches the selection process.
We interviewed one of the. Go ahead, Cynthia.
I was just going to say that where it's random, it is based. I think we're talking about the same court. Where it is random and it's selected, there's a selection wheel. You first have to have the qualifications. You list what your areas are that you are comfortable mediating, and so it's not just totally random. There is some filter in terms of making that decision. Sorry,
we
Nelson.
interviewed one of the heads of the ADR office, and she told us that the ADR coordinators choose based on, number one, diversity, and number two, based on choosing people who have not had an opportunity to mediate in the past. And personally, the judge I work for has tried to appoint somebody, and in our borough was told that that is not permitted. But in other boroughs, I have learned that it is permitted. So it really depends upon where you are and who you're dealing with.
Yep, and again, goes into the difference in local practices and throughout all of New York, and probably I would think that maybe some of that applies to California, even though they do have the uniform rules, as Phyllis said. All right, we're at 7 minutes down to our official time. So what I want to do is now I want to start looking to the questions from the audience. We're going to start exploring those. So first one I think is we'll go in order of when they were posted, from Ellen Stein. This question I think we'll start off with Stephen, since it was his topic. How is confidentiality handled in New York in collaborative law cases? But of course, after Stephen goes, everybody else has the floor. So Stephen, why don't you take it away?
I'm not really sure what that means. I'm embarrassed to say I don't quite get it. There may be some common understanding of collaborative law cases that I'm not getting. So I'm interested to hear what others have to say.
Okay, Cynthia, you have any thoughts on confidentiality in collaborative law cases? You're on mute.
I did look up collaborative law, and I've now forgotten what it means. But I think can someone just Google it, because I looked it up and it was.
I can weigh in on that. Collaborative laws primarily been accepted more in the family law area than anything else, and it's where rather than hiring 2 child custody experts, 2 accountants, and so forth, the parties agree to a collaborative process where they choose one of each. They'll often each have their own lawyers on each side, but the lawyers agree that if the collaborative process is unsuccessful, that they will not represent the parties further in an adversary proceeding.
Well, that explains why I don't know about it, because I've never done that.
They've tried to expand it to other areas of the law, but to my knowledge, it really hasn't expanded much beyond the family law context.
Yeah, from what I know about it as well, I think that's the case in New York as well. I haven't heard about it except in family law and specifically in divorce cases where it's been used. But,
I will point out that the family lawyers do have their own model standards of conduct specific to the family law area. I am not familiar with them, but I would assume that confidentiality would readily apply across the board, as it does with the model standards that we have been discussing this afternoon.
Okay, so I think that deals with that question. And then we have a follow-up question on confidentiality. It sort of dovetails. When parties bring in family, friends, or advisors, how are they brought under the confidentiality rules, or are they included under a statute?
Well, this is something that I know a little something about. If they participate in a mediation with me at JAMS, they have to sign and enter into the same mediation agreement that every other participant in that mediation enters into. It's very straightforward. There's no special agreement for a family member. And by the way, generally speaking, if a party, again, in the area of law in which I typically do a lot of work, employment, if a party says, I want my husband, I want my mother, I want my brother to be present, then generally speaking, I'd rather have that person in the room. I'd rather have that person in the process than somebody that the party is going to be on the phone with when I'm not involved at all. And I'd rather have that person engaged. But that's a little bit of a side issue. Same agreement.
I would say the same as in California. I have everybody sign my mediation confidentiality agreement, if it's a support person. The only ones who do not sign the agreement is the support dog. I've had dogs show up in my mediations. They're either in training or for emotional support, and I don't get their paw print. But short of that, everybody in my mediation signs the agreement.
Sounds pretty discriminatory to me.
I know, against four-legged.
But I think statements made in the context of mediation by any of those folks outside of the mediation agreement, and Jeff or Phyllis, correct me if I'm wrong, would also come under all the California statutes regarding confidentiality and evidence and so forth, right?
Yeah, I would agree that when I teach mediation ethics at USC, I raise the hypothetical that one of the parties is on the phone with their accountant talking about tax accountant issues. And is that tax accountant included within the umbrella of mediation confidentiality? And I would argue yes, under the California statutory scheme. It's a mediation consultation. And so it's covered by confidentiality, under the definition that I posited in 1115C and also 1119 of the code. So yeah, I agree with you 100%, Glenn.
Okay. And we have one last question. This is perfect. We have a minute and 25 seconds on the official time. So this last question, and then we'll clear the board and we can go back to our other questions if people want. Is it possible to be appointed as a judge or court administrator at the state and federal levels without first being a law school graduated or licensed attorney? So essentially non-attorney judge or court administrator.
There's a loaded question, if ever I heard one. But in New York, in order to be a judge, you have to be an attorney for 10 years, and then you can run for a judgeship. As far as court administrator, you have to pass certain civil service tests, and that's how you would become a court administrator, as far as I know.
Right, but to broaden the question, I think that the question might be referring to an ADR administrator.
Yeah, I think for ADR, because we now in New York with presumptive ADR, we now have a lot of them hired, ADR administrators hired during the start of the pandemic. And I believe they are all attorneys.
They're all attorneys.
Yeah, I think that's and the same thing with in terms of federal, the ones that I know are attorneys. So that is, it's certainly preferred. And they also, most of them have ADR experience so that they come in with both.
Okay, Jeff, Phyllis, do you know of any, let's put a spin on it. Do you know of anybody who is an ADR administrator in California who is not an attorney? Guess not.
Yes, there have been some.
Oh, okay.
In Los Angeles County. Yes, in the past. I don't know who administers such things now, but in the past there have been non-lawyers.
Former administrator.
You're right. Julie Bronson administered the ADR program for LA Superior Court, and she learned on the job. But I think it does come down to experience and knowledge of ADR. The current ADR administrator for the U.S. Central District here is on the job experience. She took a training course to learn ADR when she was appointed to the position. She had no prior ADR experience, and it's on the job training for her as well. So technically, you probably don't need ADR experience to be a ADR administrator, but you're going to be really behind the curve, I think, in trying to fulfill the job requirements. I will point out that many of the schools, both on the East Coast and the West Coast, do offer certificates as graduate programs, do offer either Masters in Dispute Resolution as a non-LLM program, just a straight MDR, or a certificate in dispute resolution. So if one does want to become an administrator, I would strongly urge you to take maybe one of those two graduate programs so that you have a clue as to what everybody's talking about and won't be behind the curve. In terms of being a judge without a law degree, I don't know what the California requirements are. I would suspect that you have to have some legal training or have graduated.
You do. Let me just comment. There are some wonderful mediators who are not lawyers.
Correct.
And let's keep that in mind as well, that you can bring past experience from a variety of fields to mediation. If you're mediating legal disputes, you have to learn a bunch of civil procedure and evidence and some substantive law along the way, I think, to be effective. And there are some very fine people who came from careers, backgrounds other than law, who've mastered those skills and are outstanding mediators.
I agree with you, Jeff. I think the question was posited in the sense of no background in ADR. Can you just jump into it? There are definitely some very, very fine mediators who are not lawyers.
I don't think there is a requirement in California that I know of that to be a judge, you have to have a law degree. Certainly not at the federal level. I mean, I believe, Jeff with his Harvard degree will correct me if I'm wrong, but I believe we've had U.S. Supreme Court justices who didn't necessarily have a law degree or experience on the bench. I don't think that's a federal requirement in the federal system. And I'm pretty sure it's not a requirement in the state system as well. Although, you know, now with ABA recommendations, I think you would probably risk getting a not qualified rating when you came up for, you know, you get appointed by the governor and then you have to come up for election in California periodically, all the way from the trial courts up to the Supreme Court. And so then, you know, that may not be, you know, a great thing on your resume, or, you know, to get a recommendation or lack of one that way. But I'm not 100% sure that you are required to be a licensed attorney. Rosebird was a lawyer. She graduated from my law school, so I can tell you that. She's in fact, I believe she may have graduated first in her class from Berkeley Law, at the time called Bolt Hall, which we don't use anymore.
Okay, I see there's one more question that's appeared. This one is probably the answer is going to be no, but we'll give it to the panelists anyway. Does anyone on the panel know a mediation training program that would satisfy the requirements for both California and New York? And I guess I'll broaden this requirements probably to be a court annex mediator for both systems. I certainly don't know of one, but someone does. Now's the chance to let people know about it. Now, yeah, the rules are just so varied. I mean, you can tell the person who asked that question, they mentioned Part 137 in the question. Part 137 for the California practitioners is our attorney-client fee dispute resolution program in New York. You don't have to be an attorney to be part of that. In fact, there are certain cases where they specifically do not want attorneys on the arbitration side. We have a panel. One of the attorneys has to be one of the arbitrators has to be a non-attorney in that particular program. But I don't know of any program that would fulfill all of the various requirements for both sides at the same time, considering you have different practices for all the counties. And that's it on the board. We do have one last question, which I'll put out. We are certainly over time. So before I get to that last question, I want to thank, first and foremost, in case anybody has to leave early, thank all of our panelists and also all of our attendees for your participation in this program, but particularly our panelists. Thank you so much for all the hard work and effort that you put into the program, and of course for you and the questions and the organization. It's wonderful to hear such varied viewpoints and perspectives on ADR. So I'm going to put in the last question right now regarding small claims mediation. We did touch upon, I think, all the other questions in some aspects. So I'm just going to put this one out there. If anybody has to go, of course, you can go, and that applies to attendees as well. Last question. There are certain areas where mediation can be especially successful in resolving disputes, and one of these areas historically has been small claims mediation. With the pandemic, hopefully, please God, subsiding, and in this regard, our thoughts, our prayers with all in Los Angeles and other counties in California, which are affected by the Delta variant. Do you see any need for changes in post-COVID small claims mediation practice going forward, particularly where evictions are concerned? That's open for the California practitioners first. Anybody do small claims in California that sees changes based upon COVID coming down the pike? Phyllis, you're off mute if you just.
Well, I mean, I think the small claims mediations are probably being done virtually like everything else. I don't know if the small claims, are the small claims courts open, Glenn, or are they still closed?
I don't know the answer to that, quite honestly. I believe most of the courts are still closed. I know some of them started open, and then immediately with the new, at least here in LA County, the new mandate, I think they've shut that down again. So I don't know the answer.
Yeah. So I would suspect that, we went back into requiring masks last week because we're having a surge. And so they do not expect the surge to peak until October. So I suspect for at least for the next few weeks, mediations are going to be, whether it's small claims or otherwise court connected, they are going to be virtual. And I will point out, in response to the last question about a judge being a lawyer, that somebody has looked it up for us and noted that in California, you have to I think, been practicing law for at least 10 years and been an active member of the bar in order to apply for a judgeship. So you do have to be a lawyer in California to be a state court judge. And I thank Ms. Stein for providing us with that answer.
I stand corrected.
Always. Go ahead, Cynthia.
I have a comment on small claims, actually going back to Jeff's comments originally about the pool of mediators in quarter-necks. In small claims in New York, there you do find that those tend to be the newer mediators. And that's actually, it's specifically, not specifically, but it's a place where new mediators are encouraged to cut their teeth, which is not the same as some of the other quarter-necks programs where they do want experienced mediators, like the commercial division, where there are a lot of complex issues. They really don't want people doing that who have not had some experience. So, and the other thing I wanted to just mention that we were talking about whether we're going to do mediations live, if it's, because I think it's now, you can do them live in some, in New York, in some cases. I am not looking forward to doing mediations live with masks. So for me, I'd rather continue to do online. I think with the mask, you miss so much of the face. I'd rather see it online.
I will point out that in California, at least in the LA County, a lot of the small claims mediations are being done by law students. That we have, the various schools have mediation clinics, and for their advanced students or even the beginning students, they will go to, at least pre-COVID, they were using the small claims matters as training grounds, supervised. The teacher, the professor would be there or have somebody else be there to supervise. But mainly the small claims mediations were being done by the mediation clinic students, at least here in Los Angeles.
Okay. Well, I want to
Same
thank
in New York.
Oh.
They also use students.
Okay. Yeah, so it's good to see people. I think that's it. Just to very quickly clear the board, Gail Keisner asked, is there a CLE code? Barry, I believe will answer that, but the answer is no, there's no need for CLE codes because your participation has already been recorded by your being on the Zoom. All right about the Barry?
Yes.
Yep, that's what it is. All right, standard policy. So that's it. I want to thank everybody for staying for the after party. Thank you so much to our wonderful panelists, Phyllis Pollock, Jeff Kichaven from California, and Cynthia Boyce and Stephen Sonnenberg from New York. It was a wonderful program. And if you have any questions regarding CLE certificates or what else, please direct them to Barry Chase or to the Beverly Hills Bar Association, but particularly to Barry. She will, especially if you're a California attorney who wants credit, you should go through Barry. She will be able to handle all of your CLE needs. And with that, thank you again once everybody, both our panelists and attendees for participating. And we look forward to having some more of these great programs with you all. Take care and have a great night.
Thank you. Thank you all. Thank you, everybody.